Now let's talk about the important points on notarization. A sensible notary public does not draft by just simply copying in toto a document from a legal forms book. A notary public should read the statutory provisions governing the particular kind of transaction on hand, and then proceed to draft the document in accordance with the law and the particular facts of the case, briefly, clearly, and accurately. This is to avoid future legal complications and useless lawsuits. A notarized document enjoys a presumption of regularity. This means that it is a prima facie evidence of the truth of the facts stated therein, and a conclusive presumption of its existence and due execution. To overcome this presumption, clear and convincing evidence must be presented. To be eligible for appointment as notary public, a person must be a citizen of the Philippines, over 21 years of age, a resident in the Philippines for at least 1 year, and maintains a regular place of work or business in the place where the commission is to be issued, a member of the Philippine Bar in good standing, with clearances from the Office of the Bar Confident and the Integrated Bar of the Philippines, and must not have been convicted of any crime involving moral turpitude. As a general rule, all judges are prohibited to engage in the private practice of law, which includes notarization. An exception to this rule is in municipalities where there are neither lawyers nor notaries public. MTC and MCTC judges, in their capacity as notaries public ex officio, may notarize provided that all notarial fees charged be for the account of the government and turned over to the municipal treasurer, and that a certification be made in the notarized documents attesting to the lack of any lawyer or notary public in such municipality or circuits. A notary public has the following powers: 1. To perform notarial acts such as acknowledgments, oaths and affirmations, jurat, signature witnessings, copy certifications, and any other act authorized by the 2004 Rules on Notarial Practice. 2. To certify the affixing of a signature by thumb or other mark on a document presented for notarization. And 3. To sign on behalf of a person who is physically unable to sign or make a mark on a document. As to notarial limitations, no notary shall possess authority to do any notarial act beyond the limits of his jurisdiction. He must exercise his duties with due care and with due regard to the provisions of existing law. A member of the bar who performs an act as a notary public of a disgraceful or immoral character may be held to account by the court even to the extent of disbarment. Thus, a notary public who notarized a document executed between the husband and the wife to take unto himself a concubine, and the wife to live in adulterous relations with another man, was guilty of malpractice, and was suspended for 6 months with admonition that a repetition of the same act in the future will be dealt with more severely. So that's it for our review on notarization. Thanks for listening.